We have a new document. Let's get it. Hey guys, this is Jules with True Crime Reactions. Like I mentioned yesterday in my community tab, there is a brand new document that dropped in the Idaho 4 case. It's about 40 pages long. We're not going to go through the whole thing. For one main reason, we talked about a big part of this motion already. We've already talked about a huge portion of this 40 pages because it's the Intercept article. Remember whenever we were going through the stuff that Gabriela Vargas testified about how there's unethical and immorally wrong and illegal things happening when it comes to the police obtaining genealogical information for cases. So they added a lot of pages of that into this, but let's just go ahead and get started with the important parts. Okay, so this is the response to the state's notice of their intent to not cross-examine defense witnesses. This also has something to do with district court decisions and records to explain witness contact. Witness contact has to be Gabriela Vargas. Comes now Bryan C. Kohberger by and through his attorneys of record and hereby responds to the state's notice of intent not to cross-examine witness, district court decision, and records to explain witness contact. Procedural history. This court conducted a hearing on August 18th of 2023 on Mr. Kohberger's third motion to compel. 4 witnesses testified for the defense, and the state reserved the right to cross-examine 2 witnesses. On August 30th, the state filed notice that it does not intend to reopen the hearing and cross-examine the 2 witnesses. Response. And this is the defense speaking. Referenced in the state's notice of intent not to cross-examine defense witnesses and all the rest of that is a 3rd District Court transcript from CR 14-20-07840. Okay, that is the article, not the article. That is a transcript that we went over where the court basically told the state that they're obviously required to hand over everything that they have, but they're not required to go and find things that they should have that they don't. Because the defense, apparently, the way that from what I'm recalling, the defendant had the right to know exactly what pointed him out. But the court wasn't going to make the state, take any extra steps to go and get any of the things for the IGG, that they didn't already have. That if they had it, they had to turn it over. If they didn't have it, they weren't going to be required to go and find it. Okay. So this is their very specific response to that being included in the state's information. At first blush, it appears the issue before Judge Whitney in State versus Dalrymple was that the state was seeking a protective order relating to a database that produced information leading to Mr. Dalrymple's arrest. However, the decision Judge Whitney announced was on a different issue and was made without the benefit of expert testimony relating to the forensic investigative genetic genealogy process. It is noteworthy that even without the benefit of that testimony, Judge Whitney concluded that the state needed to turn over in discovery everything in its possession relating to genetic genealogy, and the defense was welcome to bring further motion on the issue. I mean, honestly, is it noteworthy that the judge did the right thing by stating that the state needs to turn over everything in its possession? I mean, the defense is kind of using that like, oh, that's a one-up. But in all reality, we know what happened there. Yeah, duh. The state was required to turn everything over, but they're not required to go in and get anything into their possession and they don't already have in possession. So I don't know why the way that I'm reading this from the state, it makes it seem like they're counting that as a win. It's not really a win. Especially whenever the defense has stood up in court and told the judge that they don't believe that the state is purposely withholding anything from them. Okay. This court is asked to decide something different. The information sought by Mr. Kohberger through his motion to compel is the same information that the state seeks to protect with its motion for protective order. The SNP profile created on behalf of the state and the genetic genealogy process directly used by the state to identify Mr. Kohberger. Mr. Kohberger is not asking for a genetic genealogy database, rather the analysis and documentation utilized to identify him. Mr. Kohberger has also asked for the SNP profile, and the state has agreed to provide it. The state wrote in its June 2023 motion for protective order that it would provide the SNP profile. Again, during the August 18th, 2023 hearing, the state stated it would provide the SNP profile. At this time, Kohberger has not been given this information. I'm going to have to go back through some documents. Unless you guys know in the comments, I mean, I'm still going to go and validate, because I'm not just going to take a comment as the answer to my question. But what was deleted, guys? Because didn't they state that something was deleted? Like, I could have sworn we heard that the profile was deleted out of the system. And they made it sound as if it was like deleted out of existence, which is why we were having so many issues with like the defense seeing anything. Let's just continue. I'm going to have to go back. Okay. This court is left to decide whether to shield the analysis and documentation developed and used to identify Mr. Kohberger, or to order it be provided for his defense. This court makes its decision with the benefit of expert Steve Mercer explaining the duties of attorneys to examine this evidence and the types of legal decisions that could be made based on this evidence. This court has the benefit of knowing, based on expert testimony, how SNP results are produced using bioinformatics. Further, expert testimony described how genetic genealogy tracing is conducted and all the documents generated by a genetic genealogist showing the analysis and result. Further, this court has the benefit of expert testimony describing how SNP testing can be compared against STR testing for contaminants and mixtures, as well as how the SNP and genealogical data can impact statistics. Lastly, this court has knowledge of the intricacies of prohibited law enforcement access to various DNA databases. The testimony the court received in the hearing relating to this loophole is not something Judge Whitney had the benefit of knowing. It is important for the court to be aware that this same information has now been published on August 18th, 2023 in the Intercept. And remember, guys, I felt weird about this article, but it could have literally just been coincidence, because there are times where things just happen in the universe that are complete freaking coincidence, okay? That article was released hours before Gabriela Vargas got on the stand. And Gabriela Vargas, from what it sounds like, was sort of a last-minute thing, but I don't know why it was a last-minute thing. They haven't told us the reason why her paperwork was filed like the day before court, because that's why the state had an issue, is because she was like super last minute, but she made it sound on the stand like someone related to the case contacted her like in the very beginning of August. So she'd really only been at the most, guys, at the most 18 days in to even knowing anything about this case, looking into this case, talking with people about this case, working on this case, looking into this case. 18 days. 18 days. But that article came out a handful of hours. And it was really crazy to me. But articles like that, as long as it was and how detailed that it was, that wasn't just like done like that. This is someone who had spent time traveling around to different places, visiting different people to be shown things physically on computers, being shown the process of how this stuff works. So, I don't know. It was very, very crazy to me that it dropped the same day, a couple hours before. But again, it could be one of those universe things. That's all I'm going to say. Okay. This article details forensic genetic genealogy and the loopholes utilized to obtain information in contradiction of authorization. Attached as Exhibit A. Yeah, it's the full article. The Intercept is an online journal that has existed since 2014. Open Source Information states this is an award-winning news organization dedicated to exposing the powerful and holding them accountable. And I will go back to my video where we discussed this article and grab the link, and I'll have it in the description box. I'll also have the link for the motion itself in the description box, so you can go click and read for yourself to either one. The court in State versus Dalrymple also lacked the following documents that established the relationship between the Idaho State Forensic Laboratory, local police departments, and prosecuting entities in the state of Idaho. This court received such documentation attached to the declaration of Ann C. Taylor in support of third motion to compel. So this is another attachment that they have, and I looked at it, but it is like basically a letter from the Idaho State Lab that's like, we're so excited to announce that we've just spent all these bazillions of dollars on all this equipment, and it turns out that they didn't do a damn thing for like any of this, because the FBI is the one who got the IGG information. So it's interesting that that's what we do see here, is that the state lab that should have been working on all of this, like, had all these grants given to them and all this new equipment and all these new partnerships and blah, 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 blah. And then they did nothing with it for this case. Shut it down. I mean, I don't know. Maybe that's just premature thinking, but I was just listening in on a story of this is sidetracking. I was just listening in on a story of a little town in Texas, like 3 hours north of Houston. It only has 250 freaking people living in it, guys. And it has 50 police officers. And there's like a whole freaking story. There's a whole story to it. But this is the same kind of concept, because those departments and stuff that was causing all of that excess is getting shut down after getting $1 million worth of revenue in just tickets last year. In a town of 250 people, that's $4,000 like per person. So if Idaho, got all this funding and all this equipment and all these things, what good are they? What are they doing if they didn't do crap worth of crap in this case? One of the most ridiculous cases that Idaho is gonna see, one of them. And the lab with all of these, oh, we're so excited to announce this, accomplished shit. I don't know. Okay, rant over. This memorandum shows that Idaho utilizes federal money to work with Othram laboratories to identify suspects in certain cases. This memorandum shows the intricate relationship between agencies for identifying which cases qualify for identification through genetic genealogy. So here it is again, the defense themselves are the ones, again, because the state, as far as I remember, there hasn't been any documentation from the state with Othram's name physically in it. The defense now, for the second time, has put Othram's name in the documents. But then one of the attorneys stood up in court the other day and stated that it's just talk that it's Othram, that they physically haven't seen anything to concretely tell them that it was Othram. So this is just showing that there is a relationship between the Idaho State Lab and Othram per the, oh, we're so excited, okay? But that still doesn't mean that Othram was the one who worked it. I'm just going to go ahead and state Othram was in on this. Because at this point, if Othram does not end up being a lab after everything that we've heard, it wouldn't make sense. It just would not make any sense, which would actually be so fitting for this case, honestly. In Mr. Kohberger's case, the Latah County prosecutor, the Moscow Police Department, the Idaho State Police, and the FBI worked together to investigate the case and identify a suspect. At some point, genetic genealogy was utilized for identification. I love how at some point is italicized. But I mean, honestly, if the defense hasn't gotten any information over, then the defense might not even have the exact date that their client was pinpointed. That information remains withheld right there. That information remains withheld from Mr. Kohberger. Mr. Kohberger does not even know when this began or when he was supposedly identified. See, how is any of that, just flying with the judge? How is any of that flying with the judge? That is just insane. That after all this time, this man has been in jail since basically the beginning of the year. We're in September. 9 months of just him being in the jail. A month and a half for them to conduct what put him in jail. And 9 months later, he still doesn't have the exact date that he became a suspect. I just don't understand. The memorandum contains a requirement that the Federal Department of Justice policies must be adhered to, and that agencies must sign a memorandum of agreement to follow such policies. The DOJ has a policy regarding forensic genetic genealogical DNA analysis and searching. And this was attached to the third motion to compel, and they've attached it again. The policy requires that the prosecutor and investigating agency collaborate. That policy also requires that investigative agencies only enter and search DNA databases. I'm sorry, but that being separated right there, like through my brain. Okay, let's start that sentence over. That policy also requires that investigative agencies only enter and search DNA databases that permit law enforcement to use their services. That policy requires that all forensic genetic genealogy profiles, account information, and data shall be retained by the investigative agency for potential use during prosecution and subsequent judicial proceedings. There is a relationship between local, state, and the federal government to work together. DOJ policy requires retention of analysis and materials for use in judicial proceedings. This knowledge, in addition to the potential for misuse of information, is something that is discoverable and necessary to Mr. Kohberger. Idaho Rule of Criminal Procedure 16A reads, the prosecuting attorney's obligations under this paragraph extend to material and information in the possession or control of members of prosecuting attorney's staff and of any others who have participated in the investigation or evaluation of the case, who either regularly report or have reported in that case to the office of the prosecuting attorney. Anything, any agency, anybody who is an official figure of authority who has the duty to do whatever you have signed to be your duties, you have to do everything that the DOJ states in these policies. Which means that any of the information that was gathered by anyone who touched anything official on this case is supposed to be available for technically both sides. The state should be double checking everything that they're getting. They should be making sure that everything that they have is solid AF. But they don't even have stuff. They really just don't. And they've made that clear. They've made that so super clear that there's a lot of stuff they should totally have in their possession that they don't. And they have like no want or care to go and get it. They're just acting like it's completely irrelevant. Is it irrelevant, or do you not have it because it doesn't exist and you don't have any work to actually show? Like, that's basically where I'm at this point. Because they've literally shown us no proof of their work. None of it. And not showing us is one thing, but they're claiming right here that at this point, all this time later, that the defendant, the man who will be facing a firing squad, still has not seen this information himself. That is just so wild to me. That is so wild to me. The duty of disclosure is an obligation of not just the individual prosecutor assigned to the case, but of all of the government agents having a significant role in investing in prosecution. What? Okay, see, it's 2023. Every device that you can think of, can touch, type text on, talk into, has spell check, grammar checker. Okay. I'm so tired of this. Because this is supposed to be like the creme de la creme. All right. We should never see spelling mistakes, grammar errors, things like that should not be in these court documents. So I'm going to read the end of that one more time while I sit here annoyed as hell because I'm so tired of these I'm so tired of all these errors. And it's both sides. Both sides are just so careless. They're careless. I know that they're like trying to push a bunch of documents out. This isn't the only case they're working. Okay, but grammar and speller check or whatever is literally like one button. One button. Or the damn sentence is like highlighted and you just got to click it and it fixes it for you. Okay. This sentence makes no sense. A significant role in investing and prosecution the offense. In investigating and prosecuting the offense? Probably should have been the way that went, I guess. Okay, I guess this rant's over too. The FBI has been compelled to turn over its CAST report related to cellular data evidence and its investigation related to identification of the car. The investigation related to the car includes hundreds of names of individuals owning a white Elantra. Again, owning a white Elantra. You guys are getting careless, bro. The evidence held regarding DNA is no different. The court in Dalrymple incorrectly permitted the state to hide material from the defense by claiming they did not have it. That is not how discovery works when the state decides to work with outside agencies to take liberty from someone. This court has thus far shown that the FBI does not exist outside the discovery rules. It should not grant them immunity now. I mean, I agree. Miss Ann, I agree. Conclusion. The transcript provided from the Judge Whitney does little from the Judge Whitney. Oh my God. Okay. Oh, keep it together. The transcript provided from Judge Whitney does little to instruct this court about what should be decided. This court has a different question. Mr. Kohberger requests materials and analysis, not a database. These materials are required by the DOJ to be retained for use in judicial proceedings. This court has the benefit of understanding the process and the materials that were created in this identification of Mr. Kohberger by the state and its agents. Mr. Kohberger respectfully requests the court order the state to disclose the materials. Mr. Kohberger is happy to comply with any limiting order the court deems appropriate. Okay. That's it for the actual stuff. Okay, so we went over this, guys. I read you guys some of this. I didn't read all of it because this thing is hella long. But I read the important parts about how they were shown physically. Someone sat down and showed this person who wrote this article physically on the computer the loopholes, showed them the buttons that gets clicked, showed them all the things, showed them all the proof that it does what they're claiming it does. They showed it to them. It's a very, very, very long article. And see, that's what most of this stuff has been. It's just the article. Okay, we should be coming to the end. I don't know why they felt the need to add the newsletter and all that other stuff. And then we've seen this, I don't even know how many times. But since July 28th of 2021, the Idaho State Police Forensic Services Laboratory has been extremely excited to announce that they have secured a Bureau of Justice Assistance grant to fund genetic genealogy testing and searching of unsolved Idaho cases. This has been my biggest problem, is that they had very specific genetically related upgrades to the way they do things. And maybe them sending out is that upgrade. But if they're partnered to work with Othram, because of this little, did the FBI just take over? But I think that's a very important thing here to know, because we've been told that they sent stuff over to Othram, and then Othram was told to stop what they were doing because the FBI was taking over. But who made that call? Was it Idaho or was it the FBI? Because we know, like I said, the FBI was helping on the case We know that. But did the FBI just say, stop what you're doing and give me everything, we're taking over? Or did Idaho, like, ask the FBI to take over, and what would have been the reasoning? If they've had this partnership with Othram, that whole thing is very confusing. I would love to know who made that call. Do we know that yet? I don't think we do. But that's it for the documents. Again, the link for the document itself and then a link for the Intercept article itself is going to be in the description box. But that is it, you guys. See y'all.